As more and more overseas goods float in China, the commercial frictions have also increased. Over the past couple of days, a widely discussed intellectual property case in China is Louis Vuitton winning the lawsuit against moliy. The case caused widespread attention for two reasons. On one hand, the plaintiff is a world-famous luxury brand, while the defendant is just a Chinese domestic milk tea shop. On the other hand, the compensation reached over 10 million Chinese yuan. It's really the biggest trademark infringement case in recent years of China. Now, we will focus on the legal dimension. Except the public sentiment, I see many comments on the internet believe plaintiff's trademark originated from traditional Chinese symbol and known as its flower print. A foreign brand has registered in China and now sues a local domestic company. It's unfair. But now we won't talk about such arguments. If judgment rulings were by public emotions rather than the law, courts will no longer deliver judgments based on laws. I think the ruling in the case holds solid ground. First, moliy Tea's four-leaf logo was submitted to Intellectual Property Administration, but has rejected to register before. Second, the trademark registered by Louis Vuitton visual similarity with used by moliy Tea's products. At first glance, I even could not distinguish between the both of them. That means brands with similarity cause a high risk of confusion in consumers, even don't need to be the same. I also see other comments on the internet have raised a suspicion. Plaintiff's trademark are registered under Class 18 in trademark law, covering leather goods and luggage, but defendant uses it under Class 35 for advertisement and Class 43 for good service. So they say, while it can be applied across unrelated product and service, but under this, Louis Vuitton is a well-known trademark all over the world, and well-known trademarks can be protected across different categories under current law. Now we can talk about the 10 billion Chinese yuan compensation. Judges in China always calculate infringement damages for 4 steps. First, calculate the trademark owner actual losses, and if it cannot be calculated, courts will see the legal profits used by infringer. And what if the profits cannot be verified? What can we do? The court will refer the registered trademark license fees as compensation. And if all above cannot be measured, the cap on damage will not exceed 5 million yuan in most conditions. So in this case, if defendant appeals and submitted other evidence to prove that plaintiff losses were lower, the higher court will reduce damages probably. In the end, Louis Vuitton win the case and get a final and binding judgment. moliy will not only need to pay compensation, but also ban to use the 4-leaf logo in any conditions.